SJC-11516 in the matter of Suzanne T. Dwyer-Jones.
Good morning.
Morning.
I'm Thomas R. Kiley. I represent Suzanne T. Jones. This is a matter that the court, under its modified rules, has suggested is appropriate for full briefing and argument because it is the first case since you adopted changes to Section 13 of Rule 401 in 2001 that the third clause has ever been implicated. I have to start by saying I'm not sure this is the right case for you to consider that, only because at the time of my hearing before Judge Gantz, I didn't know that the third clause existed. It's not reported. It's in the black book. I know I maybe should have checked the green book. The Section 13 has a clause.
13 paren 3, that's what we're talking about? No.
13.1.
13.1, third clause.
One third clause was the order, Justice Botsford.
Okay, I've got it.
Maybe the reason you're not getting these cases is that the black books to which I turn, as opposed to the desktop, does not have the clause in it, does not refer to the 2001 statute. So when I appeared before Judge Gantz, we did not argue about the specific provisions of this rule, of this particular clause, and indeed, when you look at the appendix that I've provided in my brief, you're going to see that it isn't there. Nevertheless, the argument that I advanced, which I think persuaded you to take the case, relates to Section 13 of Rule 401 as a whole. The argument is essentially that it is a comprehensive provision that covers all of the situations that might exist when somebody has a potential mental or physical disability, and that the circumstances under 13 parens 1 were not controlling because it is not what occurred in Maine. This case came before Judge Gantz. Originally, there had been a notice of convictions out of state. The matter was remanded to the board for consideration. A year or so later, the board came forward not with a petition for reciprocal discipline under Section 16, not with a petition for discipline because of the underlying conduct, but because of a determination that had been made in the Maine court, which they were equating with a determination of a disability and a transfer to disability and active status. The reality is that the decision in Maine was a suspension. That's what it was labeled. It was a suspension with conditions. It was not a determination of a declaration of incompetence. It was not a guardianship. None of those things occurred, and it was also not literally a transfer to disability and active status.
But let me just ask you this question. Take what you say, and the matter, let's just say, comes before Justice Gantz as a Rule 16, Section 16 reciprocal discipline, because the Maine Supreme Judicial Court has entered a suspension for a year, I believe. Right?
Justice Gantz issued a suspension for a year. The Maine SJC did not. There's a slight variation in the relief that Bar Counsel sought and what Justice Gantz imposed. Justice Gantz imposed a one-year suspension. The court in Maine imposed a suspension on conditions, and the conditions were that Ms. Dwyer-Jones was going to have to do certain things.
Right.
So she's done those things. A petition is pending. That's not before you. But there's again, Bar Council asked for a suspension until further order of the court.
But I'm reading, did it change? It says, this court imposes a 1-year suspension from the date of this order with conditions as specified below. Isn't that
That you're reading Maine.
Yeah.
Yeah, and what I'm saying is Justice Gantz did not impose those conditions. He issued a straight 1-year suspension.
So his was less onerous than the main?
I think more because of the collateral consequences of the order.
What do you mean?
I think
I'm having trouble understanding what the problem here is. Are you saying that that the single justice didn't have the capacity to impose the identical discipline if he wished to?
what I'm saying is that if you're going to move under Section 13, follow Section 13 literally. If you're going to move under Section 16, follow Section 16 literally.
And
under Section 16, the judge could have imposed exactly identical discipline, wouldn't have been bound by it, could have exceeded, could have gone less. And I think Mr. Marshall was here on one of these cases earlier in the term. Mr. Birnbaum, I think that the court clearly articulated that rule in the Birnbaum case. All with the goal of, that has existed as long as I've been arguing these Bar Council cases, that there be equity or equal treatment, that we avoid marked disparity in the way we deal with people. And I think the outcome of Justice Gantz's order in this case is a marked disparity.
Because you say it is more onerous, and I'm having trouble understanding that. Won't it just terminate at the end of a year?
The year is up. The suspension has not terminated. Bar Council's position and the way the rule would work is, if it were literally applied, is the reinstatement process would have to occur. Bar Council's position is all of the reinstatement rule doesn't apply. The automatic provisions for suspensions of 1 year doesn't kick in. We would have to apply. We would have to take the MPRE by virtue of the rule. This young lady would be subject to probably an additional year. And now I want to.
I'm reading the order from the docket, which says Order of Disability Inactive Status.
Yes.
This is Judge Gantz.
Judge Gantz put this young lady on disability inactive status.
Right.
By virtue of that provision in your rules, the reinstatement process will have to occur. That year is up.
Okay.
It was up in August.
Yeah.
All right, so now we're going to have to petition for reinstatement under the rules. Bar Council takes the position that reinstatement, just as if there was a suspension, will be in place, except for the provision that would apply to a 1-year suspension that would allow us to file an affidavit showing compliance with the terms.
That's assuming that somebody hadn't given at least a year and a day.
But he didn't. But let me address the disparity, because I really, unlike the cases you just heard, we're dealing with a rule you write, and we're dealing with the interpretation of a rule you have put in place,
That's why this is even worse.
Yeah, which has as its goal, in my mind, the principles that underlie reciprocal discipline, the principles that underlie all discipline, which is treating lawyers fairly, to seize these words, and equating conduct one with another so that we don't have marked disparity.
Now, in the Maine's SJC order, does the attorney have to reapply? Or does she have to at least show that she has satisfied certain conditions?
And a petition has been filed, And in the main case, as Justice Botsford points out, and what Mr. Marshall calls a roadmap, there's a roadmap of some 13 conditions for her to follow, which she has followed, and there is a petition that has been filed and it's recently filed. It has not been active.
So it's a petition for reinstatement,
Yes.
which is essentially what she would have to file here.
Yes, but I have to meet additional heightened standards, in my view, according to Bar Council. But let me address the disparity.
Before you do that, let me just back up on one point. Could Justice Gantz have issued a one-year suspension and required the attorney to file for reinstatement?
Sure.
Yeah.
Sure, I think so. I typically appear before single justices as opposed to the full bench on these matters. And I do think that the provisions of the rules give you a great amount of flexibility. I do want to address disparity because I think it's what this all gets to, or what my case is all about. The essence of the offense conduct, if you will, of Ms. Dwyer-Jones was that she had 2 operating unders and a resisting arrest that were a function of her, in this case, falling seriously off the rails. The main decision indicated that she had a mental health issue that she had controlled without incident since her admission to the bar in 1997. No discipline, no history of brushes with the law. She lost her father, she went through a difficult divorce, and she fell off the rails, and she had 2 OUIs and a resisting arrest charge. This course...
But also conduct, at least as I read the main case, there was a lot of conduct sort of associated with the investigation. I mean, things that made one concerned about capacity to practice law.
Appropriately so. I'm not suggesting that the concern was not valid. I do suggest in my brief that one's physical and mental condition is not static,
Right.
that it changes over time.
Absolutely.
And I do point out in my brief that the one piece of solid medical evidence that we had in the record is an indication that with her medication in place, this young lady was capable and did, in fact, act appropriately. But I want to point to 2 cases that were before this court with fact patterns virtually identical to the fact pattern in Ms. Dwyer-Jones' case, not reciprocal discipline cases, cases that came before the single justices here. The 2 cases are Bizanoskas and Descharnay. Can
you spell those?
I can try.
Are they in your brief?
Bizinauskas. And that attorney Peter Bizanoskas was charged with the same offenses in Wareham District Court as Ms. Dwyer-Jones, 2 OUIs and a resisting arrest. And he disposed of them last October with admissions to sufficient facts, which of course are convictions. What he did following his convictions by way of alcohol and rehab parallels what Ms. Dwyer-Jones has done in Maine. In March of this year, the single justice entered an order suspending him for 3 months, but staying that on the basis of conditions for 1 year. The conduct, it's hard to say that the conduct is identical because the summary that one has is very short, but the charges were the same, the rehab was essentially the same, and Mr. Bizanoskas didn't apparently miss a day. The case of Nicole Descharnay is also analogous to this one. Last January, the single justice in that matter also entered a 3-month suspension order, and on that occasion stated for 2 years, state execution for 2 years, under conditions. The conditions are essentially the same as the conditions on Ms. Dwyer-Jones.
How do you spell Descharnay?
Desharnais. That one is BD 2012-108. Bizanauskas is BD 2013-115. Now, in Canada, these are cases that came, I think, by way of agreement from Bar Council. There's a marginal difference in Descharnay. He wasn't charged with resisting arrest. He was charged with leaving the scene after causing property damage. And I would say she, not he, and like Ms. Dwyer-Jones, there was a probation violation, and Nicole received jail time and served her time.
So in this case, what do you say should have happened?
I think what should have happened is
Bar Council should have filed under Section 16?
Yes, or having had the case for, on a notice of conviction, done an initial case for the underlying conduct, and had we addressed the underlying conduct, Ms. Dwyer-Jones, if her 2013 or 2014 case was handled like Descharnay or Bizanauskas, she would have had a 3-month suspension on terms with the execution stayed. She wouldn't have had a bottom as she had to do in this case.
But you would agree, though, that the actual terms of the disposition could be this, even under Section 16,
Sure,
right?
Absolutely.
But just one other thing, Bizanauskas and Descharnay, they were not reciprocal cases.
They're mass cases. But again, the accident to the border doesn't matter it shouldn't matter to you. It doesn't historically matter to you. The idea is that I want to address to you, as you are the rule maker, is that as you are dealing with reciprocal cases, as you are dealing with the rules you promulgate, the goal has got to be the same regardless. And in this case, which is an illustration of what occurs, it does not work out that way.
Mr. Kiley, may I ask if Judge Gantz was made aware of Bizanauskas and Descharnay at the time of the hearing?
No, they follow.
I'm sorry?
The single justice sessions followed.
Okay. All right, thank you.
I think his order is in August and these two cases were in January and March of this year.
Okay.
So are you saying if this was brought under, I wanted to just get clarity on this. If you're saying it was brought under Section 16, and that's when you can do reciprocal discipline, right? Yes?
Yes,
So-
I'm sorry, yes.
So if you did reciprocal discipline and you simply piggybacked the Massachusetts matter
The main man.
onto the main matter and said, it is to go on unless and until you've resolved the main matter. Are you saying that there's somehow still a problem because that discipline is in excess of Descharnay and the other matter?
I want to respond very directly, Justice Lank. I'm not sure that I would have brought this matter and that you would have allowed it. I can't make that representation. But when you have a comprehensive rule as you do under Section 13, which affords people procedural benefits as Section 13 does, and you do not have literal compliance, if you will, with the things that are in the first paragraph, but it would be literal. I think that the potential for, I don't want to call it a miscarriage of justice because it would be hyperbole, but the potential for marked disparity in the way you are treating lawyers arises. And that's what I want to bring to this court's attention as you are the rule makers, as you are the enforcers. My time is well expired. Thank you for your courtesy.
Thank you, counsel.
Good morning.
Mr. Marshall, why isn't Mr. Kiley right? We've got a rule that deals with this. It has
Yes.
protections, and this doesn't comply with the rule.
It complies with a reasonable interpretation of the rule that was reached by Judge Gantz. The reason
you brought it under 13. Why did you bring it under 13?
the reason we brought it under Section 13, Justice Botsford, is because it is our position in this type of situation where a lawyer has been found to be incapacitated in another jurisdiction, Section 16 would not apply because Section 16 applies to reciprocal discipline.
But this was discipline in Maine, wasn't it discipline?
No, it was not.
It was a suspension.
It was an incapacity.
Well, it's an order of suspension
yes,
on
but
conditions. That's what it says.
Yes, but it resulted from an incapacity proceeding under the Maine rule, Section 7.3E, which is reprinted in my addendum, which specifically provides for the same type of proceedings in Maine that Section 13 of your rules provides for in Massachusetts. And that's an important distinction, which I think is at the core of why we're here. This was not a discipline case in Maine. This was a disability case in Maine. And therefore, we treated it under Section 13.
Are the circumstances in this case appreciably different than they were in Bizanauskas and Deschanais?
Yes.
Other than the fact that it was something happened up in Maine first?
Yes. The difference is that this respondent, Ms. Dwyer-Jones, was not prosecuted by the bar for her convictions. A petition was brought against her based upon the argument and an assertion that she was incapacitated and should be treated under Rule 7.3E of the Maine rules. That's the difference, and that's a big difference. To compare original jurisdiction Massachusetts conviction cases with a reciprocal disability case from Maine is essentially comparing apples and oranges.
Well, let me put it to you differently.
Yes.
Supposing she was arrested for drunk driving up in Maine and convicted, and the state of Maine didn't do anything about it, and you learned that she had been convicted up in Maine and you were able to get the police reports, how
Yes.
would you have proceeded?
If Maine was not proceeding, we would have proceeded on the convictions in Massachusetts. This is a fairly repetitive scenario that we have in the office where a Massachusetts lawyer is also a member of another bar, practices in that other jurisdiction, gets convicted of crimes in that other jurisdiction, and they come to our attention.
And given the facts of this case,
Yes.
other than the procedural facts, would Attorney Dwyer-Jones's case have resulted in a similar disposition to Bizanauskas and Deschanais?
There was more to it. I can't answer that question this morning, Your Honor, because I'm only vaguely familiar with the facts in Bizanauskas and Deschanais, and I also recall from the record that there was another arrest in the Dwyer-Jones matter. I don't believe that resulted in a conviction, but that would have changed our analysis of the case at the time when it came in. So I can't answer that question, but it doesn't apply to this case in any event, because when we did get notice of this case, we also were informed that the Maine bar was proceeding, that they were going to be doing something, and they provided us early on with a copy of the petition that they filed with the Maine Supreme Court that resulted in the finding of disability. And therefore, since we knew that they were proceeding, we waited for the opportunity to do a reciprocal proceeding in Massachusetts.
Is it clear from the papers that were before the single justice that this was not a proceeding in Maine brought as a disciplinary proceeding?
Yes. I filed a memorandum with the single justice.
Do you have the Maine papers? Were the Maine papers before the single justice? What was the record? I guess what I'm asking, what was the record?
As far as the Maine record is concerned, the only document that was before the court was the Maine judge's decision.
Which is explicitly brought under 7.3E 2B, right?
Yes, exactly. So that established the procedural posture of the Maine case as being a disability case and not a discipline case.
Well, if our rules, as I take it, seem to not, there seems to be a no man's land. You say Section 16 doesn't apply, and you clearly didn't follow all the procedures in Section 13. So what is a person like Ms. Dwyer-Jones supposed to figure out what she's supposed to do?
Well, I'm not sure that it really is a question of what a person like Dwyer-Jones is supposed to do, as opposed to a question of what Bar Counsel is supposed to do in this situation. We made a judgment that based upon the procedural posture of the Maine case, the proceeding against Ms. Dwyer-Jones in Maine was essentially a disability proceeding, just like it would have been under Section 13 of our rules, and that because of that, the order of suspension was the functional equivalent of a transfer to disability and active status in Massachusetts, and that's exactly what Judge Gantz found in his decision. And he pointed out what I think is one of the more compelling factors in this case, and that is that the Maine judge's findings that the respondent was disabled and incapacitated as a result of chronic alcoholism and bipolar disorder and anxiety and depression, those findings would have required that she be transferred to disability and active status in Massachusetts if those findings had been made in a proceeding in Massachusetts. And that's the basis of his comment that the transfer in this case, that the suspension order in this case, was the essential functional equivalent of a transfer to disability and active status. And there is case law supporting that decision, matter of Lebos, which is cited in my brief. The respondent in that case had been involuntarily transferred to an inactive status as a result of some disciplinary findings. We filed a petition under Section 16 arguing that she had essentially been suspended, and the full court acknowledged that and said that was essentially a suspension order, therefore it was appropriate to proceed under Section 16.
So,
Did you argue before the single justice that the Maine proceedings should be given affirmative collateral estoppel effect?
We argued that they should be given reciprocal effect under Section 13(1). That was our argument. That's the request of relief that we made in the petition, and we made the argument that based upon the procedural posture of the case in Maine and the findings by the Maine judge, a transfer to reciprocal disability status, a transfer to disability and active status in Massachusetts was the appropriate remedy in this case.
and what is it that Ms. Dwyer-Jones needs to do now in order to get reinstated?
Sections, excuse me, Your Honor. Under Section 13 of our rules, she's entitled to apply for reinstatement after a year. That's consistent with Judge Gantz's order.
And what does she have to do?
Which place she has to apply for reinstatement.
Right.
And she has to show, as indicated, excuse me, let me get the rule in front of me.
Under 6, subsection 6 of...
Yes.
Yes.
Subsection 6, she has to apply for, she has to file a petition for reinstatement under Section 18. And in connection with that proceeding, she has to show that the situation that was resulting in her incapacity or disability has been dealt with. On the other hand, I should also point out to you that in subsection 6D, were a lawyer placed on disability and active status under subsection 1 of Section 13, which applies to this case, where she has been judicially declared to be competent or returned to active status in the other jurisdiction, the single justice has discretion to waive a reinstatement proceeding in Massachusetts and to reinstate the person here. So if...
So assuming she is reinstated in Maine, that could be brought back to the single justice?
Exactly, that is correct.
Okay.
That is
May I
correct.
ask
Yes.
whether or not Bar Counsel has any discretion once you find out, as Mr. Kiley says, that there's this great disparity in the disposition of the case? Does Bar Counsel have any authority to recommend an adjustment in the suspension? Should that or could that have been done to avoid this proceeding?
We have some discretion in terms of which way we go on these types of cases, whether we were to file a petition for discipline based upon the convictions before the board and have hearings before the board on that petition, or whether we would go forward with a reciprocal proceeding based upon the other state's order.
I understand.
Based upon general concepts of efficiency, we tend to lean towards attempting to adopt reciprocally the order from the other jurisdiction.
I know, but my question is a little bit different. Mr. Kiley says that the outcome of this case, the one-year suspension,
Yes.
is vastly disparate from similar cases. And what I'm trying to figure out is whether Bar Council has any discretion to negotiate with the Attorney's Council a different outcome once you find out that there's been this disparate treatment of other lawyers, although this happened after the fact. So I'm just trying to figure out what can you do with that information
We
once
would
you
have
find
that,
it?
Justice Hines, we would have the discretion, as you indicate, after we make decisions about how to proceed. I disagree with the assertion that there is disparate treatment here. The fact of the matter is that Mr. Bizankowskis and Ms. Descharnay were prosecuted for their convictions. The main point I want to make this morning in this particular case is that Ms. Dwyer-Jones was not prosecuted for her convictions.
But wouldn't that make her case for another outcome stronger? If they've got a criminal conviction, she doesn't.
Well, except that you don't know about the level, you don't know about incapacity. I mean, it really depends on what the incapacity.
Right. There's no information in Bizankowskis or Descharnay about any incapacity or disability. There's a lot of information in this case about incapacity and disability. So the comparison would be, how would a Massachusetts lawyer be treated as a disability case with the same conditions as Ms. Dwyer-Jones has and as were considered by the main court? And I would suggest that there's no indication on record that the 1 year placement on disability and active status for the type of condition that this respondent had is at all disparate from the way other Massachusetts lawyers with similar incapacitating situations would be treated.
So we're stuck with the main court's decision to treat essentially a disciplinary matter as a disability matter, because all of this arose from conduct which would be subject to discipline anywhere, I would imagine. But we're limited by the fact that the main court considered this a disability case rather than a discipline case. Is that what you're telling me?
This court has ultimate authority on these cases. We made the decision to handle this case as a disability reciprocal case, and not as an original discipline case. So we're the ones that take that on. We believe that it was an appropriate decision to make. I think when you look at, I'd like to end on an analysis of really the intent of the rule. When you look at 13.1, and you look at the other categories, finding of incompetence, a guardianship, or a conservatorship, those are all vastly different types of procedural mechanisms. But the common fact, the commonality amongst those three is that there presumptively has been a finding that the lawyer had an incapacity and a disability that rendered the lawyer incapable of taking care of his or her affairs.
Let me ask you this. When you get a, I don't know anything about the two cases that Mr. Kiley mentioned, but when you get a case of a person, a lawyer, who has 2 OUI convictions back to back,
Yes.
do do you always proceed on convictions, this is the way we go, or do you actually undertake a view, maybe we should see whether there's really an incapacity here that's driving these OUIs?
Usually, we would do the latter, definitely, and usually that information is going to come from the criminal proceedings. If there has been a probationary term, as there usually is, and I believe as there were in Bizankowskis and Descharnay, we would know from the terms of the probation what the situation was. If there was an ordered AA attendance, if there was an ordered inpatient stay, which there frequently is, we would get the records on those things, and we would talk to the lawyer and the lawyer representing the lawyer.
Can you tell me, or I mean, not right off the top of your head, but would you be able to see if there are any cases in which that your office has, Massachusetts cases, obviously, not reciprocal, has ended up treating, treating a case with some convictions in it as a disability case?
I will investigate that question, Justice Botsford, and report to the court. In my experience and in my knowledge in the office, our disability and active cases usually result from serious incapacities and do not arise as a result of conviction cases. They arise more likely from client complaints about the lawyer's disappeared, something along those lines. My time is up, and I would simply rest on my brief for the other arguments I've made and ask the court to affirm the single justice decision in this matter.
Thank you.
Thank you.
Counsel.